This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today I'd like to talk about why simply denying defense by an insurer cannot support a claim of bad faith, and the fact that an insurance dispute alone is never bad faith. The tort of bad faith, in fact, requires for an insured to recover that the insurer acted intentionally to deprive the insured of the benefits of the policy of insurance. Garo Alexanian, doing business as Vet Mobile and Companion Animal Network, referred to as CAN, and together with himself sued Government Employees Insurance Company and Travelers Casualty Insurance Company of America, together Travelers and GEICO, seeking a declaration that the defendants have a duty to defend and indemnify Alexanian against counterclaims filed against him in New York, plus tort damages for the insurer's bad faith denial of his claim. In Garo Alexanian versus Government Employees Insurance Company and Travelers, a September 30, 2022 decision of the United States District Court for the Eastern District of New York, the court dealt with both the breach of contract and bad faith claims. It noted that Alexanian is an officer of CAN, which is a non-for-profit corporation that provides veterinary services. Alexanian purchased general liability business insurance from the Travelers. As relevant, the Travelers policy defined personal injury as, quote, injury other than advertising injury caused by oral or written publication, including publication by electronic means of material that slanders or libels a person or organization or disparages a person or organization's goods, products, or services, provided that the claim is made or the suit is brought by a person or organization that claims to have been slandered or libeled, or that claims to have had its goods, products, or services disparaged, close quote. The Traveler's policy, though, excluded from coverage personal injury to a person arising out of employment-related practices, policies, acts, or omissions such as coercion, demotion, evaluation, reassignment, discipline, defamation, harassment, humiliation, or discrimination directed at that person, close quote. Alexanian also purchased an umbrella policy from GEICO. On January 15, Alexanian sued Rosa Morales, claiming back rent, damage to property, and removal of property, the so-called underlying action. Alexanian alleged in that action that he entered into a contract with Morales requiring her to pay monthly rent for residing in the residential apartment managed by Alexanian and his business. The complaint in the underlying action alleged that Morales was an employee of Alexanian and Alexanian's business from September of 2015 until October 29. It also referred to Morales as a tenant. Morales filed a counterclaim alleging Alexanian defamed her. Travelers refused to defend Alexanian because he allegedly defamed an employee. In reaching its decision, the district court noted that the duty to defend in an insurance policy is exceedingly broad, and an insurer will be called upon to provide a defense whenever the allegation of the complaint suggests a reasonable possibility of coverage. It follows, then, that an insurer must afford its insured a defense unless it can show that the allegations of the complaint put it solely within the policy exclusion. If the claims asserted, although frivolous, are within policy coverage, the insurer must defend irrespective of ultimate liability. When an insurer claims that an exclusion applies, it must satisfy the burden which it bears of establishing that the exclusion or exemptions apply in the particular case, and that they are subject to no other reasonable interpretation. The court must determine only whether, assuming Alexanian's allegations are true, the defamation claim is solely within the policy exclusion. The answer to that question, according to the United States District Court, was no. Thus, the breach of contract claim could not be dismissed. Travelers also argued that to the extent the counterclaims do not arise out of employment practices, they fall outside the limited scope for which Alexanian is an insured under the traveler's policy. But to support that point, Travelers directs the court to a deed annexed to the declaration of a person named Meg Reed, which is information outside of the amended complaint, and which, even if dispositive, cannot be considered by the court on the motion before the United States District Court. In short, Travelers failed to establish that the underlying action falls within the employment practice-related exclusion or is otherwise outside the traveler's policy, and therefore the motion to dismiss Alexanian's breach of contract claim must be denied. The breach of the covenant of good faith and fair dealing claims, however, both Travelers and GEICO argued that Alexanian's extracontractual claims are duplicative of his breach of contract claims and must be dismissed. Alexanian's arguments to the contrary amount to nothing more than referring to disagreements about policy terms as deceptions and falsehoods. Therefore, Alexanian's implied covenant claims must be and are dismissed by the district court. Alexanian argued, pointing to Travelers' refusal to cover the defamation suit and alleged failure to consider Alexanian's evidence, that Defendants' refusal to defend it was a gross disregard of the interest of its insured, but a disagreement concerning interpretation of the policy, which is all Alexanian's allegations demonstrate, does not amount to bad faith. There is no separate tort for bad faith refusal to comply with an insurance contract. It's just a breach of contract. Alexanian's fraud claims also must be dismissed because the alleged false representations are the essential terms of the contract, and failure by the insurers to honor these terms give rise for breach of contract, not one in tort. The alleged misrepresentations are not collateral or extraneous to the policies, but concern the policies themselves, and therefore there is no parallel fraud claim either. Alexanian's allegations establish nothing more than a private dispute between parties as to the meanings of an insurance policy. Alexanian also tried to get attorney's fees, but the defendants argued effectively that claims for attorney's fees must be dismissed because of all of the reasons the court dismissed the bad faith claims. Therefore, the court concluded that GEICO's motion to dismiss all extracontractual claims against it was granted, that Travelers' motion to dismiss was granted in part and denied in part, and that Alexanian's breach of contract and declaratory judgment claims against both GEICO and Travelers survive, but all other claims were dismissed. In my opinion, the court was correct that a dispute over coverage is a contract action only, where the only remedy available to the insured is to require the insured to fulfill the terms of the contract. When both parties to the policy in good faith disputed the benefits promised, the contract was breached, and in this case Alexanian was entitled to defense of the cross-claim, but was not entitled to any extra contractual damages. bad faith requires more than a simple disagreement over coverage. Now, if the declaration that was not considered by the trial court in this motion was brought in a motion for summary judgment and found to be dispositive on the coverage issues, then the entire case may fail. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who asks by simply clicking on zelma.com/blog. I'd appreciate it if you liked the video, that you subscribe to my blog and to my videos on rumble.com and youtube.com. And also, if you found it useful and entertaining, please tell your colleagues so that they also can log on, subscribe to the blog, subscribe to the YouTube and Rumble videos, and also consider joining my Substack publications and my locals community. Thank you for your attention.